Counsel, almost any administrative process could be called collateral on constitutional issues, whether it's tax review as in Elgin or it's immigration issues. All of those petitioners are required to go through administrative processes despite the fact that most of those agencies can't reach constitutional issues. So I don't know what makes this situation different other than perhaps, and I'm not sure about this, the existence of the adjudicatory body, the fact that your removal clause challenge. But all of the other due process challenges seem to be the quintessential process-dependent claim. You can't get more intertwined than that. Your argument seems to be saying that any due process claim counts. What about the claim in the companion case Cochran that has been abandoned, that the SEC violated her due process rights by failing to follow its own rules and procedures? That's a classic due process claim that I think in almost every other agency action, we wait until the end of the review process for the court to look at. So it seems to be that you're saying this is unfair because I have to go through the process. But going through the process is what due process is all about. I don't understand why you are any different than any other administrative agency petitioner who has to go through the process, a flawed process, and wait till the end to have that corrected.
So, Justice Sotomayor, with respect to due process claims in particular, I don't think we're arguing for a special rule for this particular agency. As I look at the court's cases, and they go all the way back to Matthews v. Eldridge and McNary, so this would apply in immigration cases as well, the distinction that the court has drawn is between cross-cutting due process claims that don't in any way depend on the circumstances of a particular case. So if you think essentially on its face that the statute doesn't provide due process, then that does seem like a claim that is wholly collateral to the merits of any particular.
But what about if you win? You don't care how you win, meaning once you're in a case, if you've been given inadequate process but you still win, you're going to suffer the litigation cost, et cetera, but it doesn't really matter what basis you win on.
Well,
this just gives you another hole in your pocket, another card in your pocket that you can play if you lose.
I don't think that's quite right, Justice Sotomayor, which is, this isn't a case like Elgin, where there's a review process for losing your federal job, and all the plaintiffs wanted was their federal job back. This is not a situation where all we want is to not have a cease and desist order.
Oh, it is, because your complaint asked the district court to enjoin the FTC and its commissioners from pursuing an administrative enforcement action. Your motion for a preliminary injunction asks for the same thing.
Absolutely. But
so it is tied to the proceeding very directly.
It's tied to the proceeding, but it's not tied to a cease and desist order in the same way as the challenge in Elgin. We believe that we suffer a here and now constitutional injury just from being subjected to an unconstitutional agency process with respect to the removal restrictions, and we think we suffer an injury the second that we are assigned to the FTC rather than the Justice Department and effectively denied any early access to court. Those are the claims we want to bring. They're not the claim that, we wanted to have 3 witnesses and we only got 2, and gee whiz, if the ALJ would have just given us 1 more witness, that would have satisfied due process. Those are the kind of claims that are not wholly collateral, and those are the kind of claims that belong in the administrative process.